artificial intelligence brings with it a paradox. It can provide an answer with lightning speed, but it often cannot provide a reason. We are transitioning from the world of paper to the world of pixel, that the law survives not by resisting change, but by absorbing it. Technology today permeates every layer of legal functioning. The e-courts project stands as the cornerstone of the metamorphosis. A citizen in Kashmir, Kerala or Nagaland can approach the Supreme Court of India without the necessity of being physically present in Delhi and may participate in proceedings virtually. Technology enhances the judicial process, but it is human wisdom that ultimately gives its direction. Hon'ble Mr. Frederick Reinhardt, 32nd Prime Minister of Sweden, Honorable Scott Morrison, 30th Prime Minister of Australia, Honorable Mr. Shri Baburam Bhattarai, 36th Prime Minister of Nepal, very distinguished parliamentarians, lawmakers representing various jurisdictions, very distinguished Chief Justice of Madhya Pradesh High Court, Justice Sanjeev Sachdeva, senior advocates, Indian parliamentarians, Mr. Kartikeya Sharma, founder of NXT and Member of Parliament Rajya Sabha, other members of the legal fraternity from domestic and international jurisdictions, eminent academicians and students from various institutions across the world, dear students, ladies and gentlemen, good evening and namaskar. It is both my proud privilege and profound pleasure to address such a distinguished and diverse gathering of eminent government functionaries, members of judiciary, public representatives, distinguished academicians, future generations, very eminent personalities across the world, on the theme, as Mr. Kartikeya Sharma pointed out, law and justice in the era of artificial intelligence and beyond. Let me first commend Mr. Kartikeya Sharma and his entire team for so thoughtfully bringing together the galaxy of leaders and professionals I see before me. The breadth of experience and perspectives represented in this assembly reflects the complexity of the subject before us today. Allow me, therefore, to begin with a simple metaphor, one that I hope captures the essence of what I seek to convey in the course of my remarks. Dear friends, imagine for a moment a river. Its waters are in a state of perpetual flux, constantly moving, swirling, and adapting to the terrain it encounters. As the Greek philosopher Heraclitus famously observed several epochs ago, and I quote him, "One can never step into the same river twice." Yet while the water changes, the river bed remains firm. It is the foundation that gives the flow its direction and its purpose. For centuries, the law has been like that very river. The specific statutes, rules, or regulations are the shifting waters, but the riverbed, the fundamental, unshakable truth of justice, remains constant. This relationship between the permanent and transient nature of legal development is not new. If you look back at the dawn of civilization, we see the law attempting to anchor itself in the most literal sense. For instance, in ancient Mesopotamia, the Code of Hammurabi, which was their legal text covering civil, criminal, and family laws, was carved into a 7-foot tall basalt stone, unmoving and unformidable. In our heritage, Dharmashastras inscribed onto palm leaf manuscripts viewed that law was not merely a set of human dictates, but as a cosmic order that sustains the very universe. The Earth Shastra, another wonderful book of ancient times defining various aspects of law, which is an ancient a book known for its statecraft, politics, economic policy, and military strategy, views the law in a similar vein. However, in those eras, the law was bound by the physical limits of the scribe's hand and often only in the preserve of a select few who held the keys to literacy. Then came the great shift, where the advent of printing press during the age of industrial progress marked a departure from the times of inscriptions on stone tablets, and handwriting manuscripts. Large-scale mechanical printing dramatically multiplied the number of books and legal texts in circulation, expanding public access to knowledge and gradually democratizing the idea of rights. As law moved beyond the silence of handwritten scrolls to the roar of the printing press, it became accessible to the common man, yet infinitely more complex. This transition, of course, proved that the law is not a fossil, it is a movement. It is a living, breathing organism that has successfully navigated the journey from parchment to paper and from the town square to the globalized courtroom. We learned then, as we must remember now, that the law survives not by resisting change, but by absorbing it. Justice Benjamin Carjo, one of the most eminent jurists, therefore very aptly put it. He said, and I quote, "Law never is, but is always about to be." Today, we find ourselves at the edge of another great shift, perhaps the most profound and challenging one yet. We are transitioning from the world of paper to the world of pixel. The course of the river, so to speak, is entering a digital canyon where the speed of the current has accelerated beyond anything our predecessors could have imagined. But as we stand before the daunting possibilities of artificial intelligence, we must not lose sight of the river bed. While our tools are becoming more artificial, our commitment to justice must remain more human than ever. In the Indian context, this transition has resembled less a cautious reform and more a quiet yet transformative shift. It was only a matter of time before our halls of justice, long recognized by the rustle of paper and the weight of physical dossiers, began to accommodate the silent and instantaneous flow of digital data. Today, technology forms the very pulse of our institution. The e-courts project stands as the cornerstone of the metamorphosis. From the automation of filings to the use of artificial intelligence in research and analytics, technology today permeates every layer of legal functioning. The endeavor, however, has consistently been to ensure that technology is harnessed in a manner that meaningfully assists every stakeholder within the justice delivery system. If one considers the impact that technology has brought upon the judiciary and court administration, it has significantly enhanced efficiency and institutional coordination. Case management systems, electronic registers, and digital filing platforms now allow the life cycle of a petition to be tracked across the country, enabling us to identify systemic bottlenecks and areas where the process moves more freely. The National Judicial Data Grid stands as a notable example of this foresight. Not long ago, a notion of a real-time public dashboard displaying pendency across thousands of court complexes would have seemed improbable. Yet, today, it is a living reality that reminds us that while the waters of technology are rising, we have spent years carefully building the vessel that will carry us through them. For members of the bar, the integration of technology presents both challenge and opportunity. Automation has reduced the burden of routine clerical work, enabling practitioners to devote greater attention to client engagement, legal strategy, and drafting. Lawyers today benefit from access to sophisticated legal databases, AI-assisted research tools, and extensive digital libraries that earlier generations could scarcely have imagined. In fact, advocates practicing in smaller towns and rural regions are no longer constrained by the logistical disadvantages that once set them apart from their metropolitan counterparts. Finally, when we turn to the most important stakeholders in the judicial system, the citizens themselves, technology has opened doors and were difficult to access. Online grievance portals, virtual lok adalats, and digital legal aid services have now brought the justice system closer to the common citizen. Litigants are now able to track the progress of their case online, access essential legal information, and in appropriate matters, they can resolve disputes through digital mediation. The experience of virtual hearings illustrates this transformative vividly. By conducting millions of hearings through video conferencing, the Supreme Court of India, the High Courts, and also the district courts at the grassroots level have very successfully demonstrated that the authority of law is not diminished by a digital interface, provided the quality of deliberation remains uncompromised. For many marginalized groups, including women, the elderly, and the persons with disabilities, the shift proved especially significant as the journey to a courtroom had often been a formidable barrier for them. The practical effects of these reforms are visible today. A citizen in Kashmir, Kerala, or Nagaland can approach the Supreme Court of India without the necessity of being physically present in Delhi and may participate in proceedings virtually whenever required. Indeed, a third of the matter before my court are now conducted virtually, reflecting a meaningful reduction in geographical barriers, litigation costs, and obstacles to accessing justice. Further, The live streaming of court proceedings now allows citizens to participate and observe how the court engages with arguments and how judicial deliberations unfold. This measure has strengthened transparency, fostered a more informed public understanding of the judicial process, and helped dispel the misconception that the judiciary functions behind closed doors. More recently, the Supreme Court E-Committee has initiated Phase 3 of the E-Court projects, which has formally begun the process of digitizing the entire court record and making e-filing and e-payments a reality across all court complexes in the country. As we continue to navigate this digital stream, we are beyond cognizant that we have arrived in this age of artificial intelligence. To some, this may feel like a storm gathering on the horizon. To others, it appears to be the dawn of a new capability. But my dear friends, in the world of law, we must remember an old piece of wisdom that says, and I quote, "You cannot stop the wind, but you can build windmills." Our task is thus not to retreat from this advancement, but to harness its energy into a structured, responsible framework that serves the ends of justice. Within the Indian judiciary, this transition is already reflected in several pioneering initiatives that are setting important benchmarks. One notable example is the software known as SUVAS, that is Supreme Court Vidhik Anuvad software. This is an artificial-driven translation tool that advances the core objective of access to justice. In a country as linguistically diverse as India, the language of the law has often posed barrier. SUVAS, the software which I am talking, seeks to bridge this divide by translating complex judicial decisions into 16 regional languages. In doing so, it enables a farmer in rural Tamil Nadu or a small trader in West Bengal to read a Supreme Court judgment in their own mother tongue and understand the reasoning that underlines it. As of early 2026, the system has expanded to cover nearly all scheduled languages, transforming the promise of wider legal accessibility into a practical reality. Another software, Space, we have introduced. That's a Supreme Court portal for assistance in courts' efficiency. Presently, it is at the experimental stage of development, and it is intended to enhance judicial efficiency through the use of advanced analytical tools. The system is designed to sift through vast volumes of precedents, statutes, and factual records within seconds, identifying relevant material that might otherwise require weeks of human effort to locate. In this manner, technology assists the judicial process by enabling more focused and informed deliberation. Looking to the immediate horizon of 2025 and 2026, the judiciary is preparing to introduce a new generation of specialized system, including Digital Courts 2.1 and LegRaw. LegRaw is envisioned as a legal research and analytical assistant designed to support judges in navigating complex legal materials with greater ease. Digital Court 2.1, on the other hand, incorporates features such as voice-to-text transcription and translation tools to assist in the dictation of orders and judgments. At the same time, newer e-filing modules are being developed with AI capabilities that can detect technical defects at the point of submission, such as missing annexes or inconsistencies with pleadings. This preliminary screening ensures that by the time a matter reaches the judge's desk, the record is structured, complete, and ready for judicial consideration rather than clerical correction. Keeping in mind the rapid pace at which artificial intelligence continues to evolve, we have also established the Supreme Court Artificial Intelligence Committee, headed by one of my colleagues, and Justice Sanjeev Sachdeva, sitting in the distinguished audience, is one of the senior members of that committee, to guide the responsible adoption, development, and deployment of AI tools across the Indian judiciary. In fact, at the recently concluded India AI Impact Summit, the Supreme Court of India had the opportunity to engage in substantive deliberations with several leaders and stakeholders in the global AI ecosystem. During these discussions, I explained and outlined the progress we have made in integrating AI into aspects of our judicial processes and the manner in which we hope to strengthen these systems further through responsible technological adoption. Most importantly, I emphasized that any such integration must remain firmly anchored in the values of institutional integrity, fidelity to the rule of law, and our continuing commitment to expanding access to justice and ease of justice. Yet, as we marvel at the lighthouse beam of technology, we must also be wary of the shadows it casts. There are some serious challenges that sometimes it might raise before us, and therefore we need to take care of that part also. For all its brilliance, artificial intelligence brings with it a paradox. It can provide an answer with lightning speed, but it often cannot provide a reason. This is what has often been termed as black box problem. In our courts, justice is not merely a mathematical output. It must rest upon careful reasoning and principled legal analysis. If an algorithm cannot account for the logic that leads to its conclusion, it falls short of a central requirement of our legal tradition, namely that justice must not only be done, but must be demonstrably done through a transparent and reasoned order. What I seek to emphasize is that artificial intelligence cannot replace the human judgment that lies at the heart of the justice delivery system. We are already witnessing troubling instances of what may be described as synthetic or artificial generated judgments being cited in court proceedings. In some cases, courts and members of the bar have relied upon precedents that simply do not exist. Decisions that were the product of AI generation rather than any authentic judicial record. In such situations, we have made it clear that reliance on fabricated authority cannot be treated as a mere lapse in research or decision making. Rather, it constitutes serious professional misconduct. These developments serve as an important reminder. When artificial intelligence can undoubtedly assist in streamlining processes and handling large volumes of information, it lacks judgment or consensus. It may replicate the form of law, but it cannot comprehend its spirit. Ultimately, the human judge remains the final and indispensable guardian of truth within the justice system. Therefore, to navigate these challenges, we must pursue a responsible path that treats technology not as a master, but as an instrument in the service of our twin objectives of access to justice and ease of justice. When I talk of access to justice, I mean to that access ensures that a citizen can approach the law without undue barriers, while ease ensures that the legal process, once approached, is not an impenetrable labyrinth. This requires a human centric framework in which routine and mechanical tasks are entrusted to technology, allowing the moral and interpretive dimensions of adjudication to remain firmly within human hands. Artificial intelligence may assist in sorting of documents or scheduling of hearings by relieving the system of these administrative burdens. It enables judges to devote their full intellectual and moral attention to the more complex questions before them, where careful reasoning, context, and human sensitivity remain indispensable. It is evident that the courts of tomorrow will be both technologically advanced and deeply anchored in enduring legal values. We are moving forward what may be described as a smarter court where tradition and innovation exist in careful balance. Ultimately, ladies and gentlemen, artificial intelligence may illuminate patterns within vast oceans of data and assist in navigating complexity. That responsibility remains with the judge. In that sense, technology enhances the judicial process, but it is human wisdom that ultimately gives its direction. As we journey into the horizon of artificial intelligence and beyond, let us revisit the picture I asked you to paint in the beginning. Imagine the law and artificial intelligence as two mighty rivers, one ancient, flowing with the wisdom of centuries, and the new, swift and shimmering with the reflections of boundless data. At first, they run on separate courses. The old river meanders with caution, the new rushes with youthful vigor. But inevitably, they meet, intertwining in a vast confluence where currents of tradition and innovation both swirl together. If we guide their merging with care, their waters will carve a single channel, a river that carries both reason and morality, logic and empathy, flowing steadily into the ocean of justice. It is in this union, neither stagnant nor reckless, that the future of the law will find its enduring and everlasting strength. Thank you very much. Thank you for inviting me and giving this opportunity to share my views with all of you. Jai Hind, Jai Bharat.